Are gun manufacturers liable for mass shootings? I'm Susanna Woodhead, and this is Scholar's Mate. Hello and welcome to Scholar's Mate. I'm your host, Susanna Woodhead. In 2005, President George W. Bush signed the Protection of Lawful Commerce in Arms Act, which shields gun manufacturers from lawsuits again, except under certain circumstances. But in recent years, after mass shootings in Newtown, Connecticut, San Bernardino, California, and most recently Orlando, Florida, gun control advocates have challenged this law, arguing for a broader definition of gun manufacturing liability. So how responsible are gun makers for shooting deaths? Joining us to discuss the issue is Andrew Closter, legal fellow at the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. He was previously the Justice Robert H. Jackson Legal Fellow at the Foundation for Individual Rights in Education. He has been published in the Stanford Law Review Online, the Journal of Transnational Law and Policy, and the George Mason University Civil Rights Law Journal. He is a graduate of the New York University School of Law. And also joining us is Alla Lefkowitz, a staff attorney with the Legal Action Project at the Bradys Center to Prevent Gun Violence, where she represents victims of gun violence and their families against negligent gun sellers and challenges laws backed by gun lobbyists. She graduated from the Duke University School of Law in 2010. Prior to joining the Bradys Center, she was a litigation associate with the law firm of Scouten, Arps, Slate, Mager, and Flom in New York. Thank you both for joining us.
Thank you.
Thanks for having me.
So Alla Lefkowitz, why should gun manufacturers be held liable for misuse of their products?
Susanna, thank you so much for having me here, and I'm so happy that you're hosting this very pertinent debate. And I think to fully answer that question, you have to take a step back and kind of understand the general rule that we have in civil litigation, which is that every member of any industry, of any service, if they produce a product that is dangerous, or if they market a product in a dangerous manner, or if they market the product purposely to dangerous people, they could face civil liability. That's how we as a society keep our citizens safe. As you mentioned, PLACA, the Protection of Lawful Commerce in Arms Act, flips that script, and it actually gives the gun industry, as interpreted by a number of courts, an unprecedented immunity that gun violence victims, in many cases, are the only victims in the entire country who are not allowed to challenge wrongs by a certain industry, by the gun industry here, when they are injured by wrongs by that industry. Gun violence victims should be entitled to at least the very same rights that everyone else had if they're injured by a car that's manufactured in a dangerous way, if they're injured by an oil spill that results from an oil rig, by a doctor, by a lawyer that commits malpractice, anything. I think that gun violence victims, and particularly victims of mass shootings, have the same rights at least as they do.
And Andrew?
Well, I guess it's hard because I agree with pretty much everything that she said, and I just am not fully sure how that deals with the law that we've been talking about. So let me just, a little bit of my background. I don't come at this, I don't litigate these issues, and I generally don't even talk much about the Second Amendment, but I do deal with tort law, and I do deal with civil litigation and civil liability. So I think Alla was correct that there are, when someone is hurt by a product, that we have, if we have some sort of breach of duty by the manufacturer, that person should be able to sue. The law says, so back before this law was signed, there were some aggressive actions by some members of state and local governments to try to to reach into the deep pockets of gun manufacturers. And here's what they weren't saying. They weren't saying that the gun manufacturers manufactured a gun that accidentally went off and shot someone. I think if a gun is faultily manufactured, we would all agree that the gun manufacturer should could and should be liable in tort. And it's my understanding that the federal law we're talking about still allows that. Similarly, if they sell it to someone that they should know is going to misuse the product, they could be held liable in tort. And then finally, mismarketing. If a gun manufacturer markets something faultily and they say this can shoot rounds this fast, but it actually shoots slower or faster, or they say the gun is proven to do this, but it's not proven to do that, or if they say the gun is endorsed by all of these parents organizations and it's not, if they lie, if they do any of these sorts of things, there are consumer protection lawsuits that could be filed. It can and still should be filed against the consumer manufacturer or the gun manufacturer. All of that is not a part of the law as far as I understand.
Okay.
What we're talking about is holding the gun manufacturer liable for the product doing what it's supposed to do. And so Bernie Sanders famously said, what, are we going to hold a hammer manufacturer liable for the injuries to someone who gets hit in the head with a hammer by a murderer? No, that's absolutely false because there's no causation there.
Okay, that makes a lot of sense. I'd love to hear what Alla has to say.
Sure, and I think if, in fact, courts and gun industry defendants interpreted PLACA in the way that Andrew has, I think we would be much closer. And in fact, the way that Andrew has described PLACA is the way that the legislators who passed PLACA defended it and why it was passed law, that any gun, it's called the Protection of Lawful Commerce in Arms Act, right? So any industry member who was negligent, who was negligently entrusted a gun to someone who they knew or should have known would be dangerous, or marketed a firearm in a way, or distributed a firearm in a way that was still negligent or dangerous, then the way that it was posed and the way that it was debated, then PLACA shouldn't have stopped those lawsuits. But that has not been the way. PLACA is actually written much broader than that. It has not been interpreted that narrowly by the courts. And just one really quick correction that I'd like to make. Guns, unlike most products, are not regulated by the Consumer Protection Bureau. They're not covered by that. So guns are the only industry, the gun industry is the only industry in the country that from when guns are made, there's absolutely no regulations on how they should or could be made. So there's no protective mechanism there. Then once something goes wrong with them, there's no civil action, civil action is much more limited that could be taken. And then there are, by the way, some federal laws that say, for example, you can't sue the aviation industry if there's a terrorist attack because we want the aviation industry to function. But what we as the federal, because we can't just take rights away from potential victims, what we as the government are going to do is say, we're going to set up a victim compensation fund. So that way airlines can still continue to function and that potential victims are compensated. None of that applies to the gun industry. There's no Consumer Protection Bureau, there's very limited lawsuits, and there's no victim compensation fund. PLACA does not allow the vast, vast, vast majority of product defect cases. And I think there's a very important case that's worth mentioning that was stopped by PLACA, purely because of PLACA. A 10-year-old boy out in Illinois found his father's gun. And he started playing with that gun with his friend, with his other 10-year-old friend, who I think is very normal. And the boy, what he did is that it was a semi-automatic handgun, a Beretta. He took the magazine out of the gun, and he thought, okay, well, it doesn't have the magazine, so it can't fire anymore. So he pointed it at his friend, and he shot and killed his friend. And so the court and the relatives of the victim sued Beretta and said, it costs about $1 to create a magazine clip, which that once a magazine comes out, the gun doesn't function anymore. Or what they could have done is put a chamber load indicator on that set that made clear, like it becomes red if there's a bullet in the chamber. Very easy fixes that could have been made. PLACA said no. He shot the gun. That's a lawsuit that would have gone forward before PLACA, rightfully so. It would have made guns safer, and it's not allowed to go forward because of PLACA.
I guess I don't know what theory, how it would have gone forward before PLACA. What was the manufacturing defect?
I think.
Assume that the law goes forward and under state law. Let's assume it's like 1999 or whatever. What's the theory of why the lawsuit would have gone forward?
I think the theory is your classic negligence and failure to warn. if, for example, a lawnmower or a chainsaw manufacturer develops a chainsaw in such a way that it doesn't make clear, for example, to a 10-year-old or an 11-year-old, that picking up that chainsaw in such a way could be potentially dangerous to the child and to anyone else around it, that lawsuit is allowed to be filed in court, okay? And then what happens is the court can say, let's figure out if there's causation here. Let's figure out if had the company done what you were asking for, plaintiff, had they made that chainsaw a little safer, would that in fact have stopped this this injury that resulted? And was it not so costly to have put in those safety mechanisms that it would have essentially bankrupted the company and then you can't do anything?
We're not really in the realm of classic tort law anymore, and there are a couple of fixes. It doesn't really seem like PLACA is the problem in that particular case. It seems to me like we've got an issue where a father could purchase a gun that has the feature, an additional feature, and he can pay a little bit more money to have a gun that may be more child safe. That's traditionally how products would be handled. Someone could say, I have a number of children, so I'm going to buy a minivan that has certain extra features that are good for my children. I'm going to have a child safety lock on the door. Not that it's required, but that I think it's a better feature to have, and you pay a little bit more, and that's typically how the market would handle these sorts of things. But the father didn't buy that type of gun, and I'm not saying that it's not a tragedy. I'm just saying that it's not necessarily something that the tort law should handle or classically would handle. And so it doesn't seem to me like the federal law is the problem in that case. So let me just take a step back about a few things that Alla had said previously. One is about a sort of trust fund. I do work in other areas of the law where you do have sort of enterprising plaintiffs lawyers that try to strike it rich pretty big, and just to name a few of them where we have set up trust funds in the same way, and we've done indemnification. One is in the oil spill context. And the argument actually from the left is that ExxonMobil and these companies like these trust funds because they pay a big payout right now and they settle the whole thing. And they're very happy about it. And that it actually hurts some of these plaintiffs in the long run. I think why we haven't seen so many gun manufacturer lawsuits historically is because the products are actually typically very safe. They do exactly what they're intended to do. Misuse by children is a constant problem, of course, but it's not a problem with the product. It's a problem with, just like if we had a spate of children picking up knives and hurting themselves, that wouldn't be a problem with the product. That's a problem. It's a problem, but it's not a problem with the product or the safety of the product. I deal with the tort law more generally than I deal with guns, and I guess one of the major issues, which I haven't brought up, what I'd like to bring up now, is the issue of causality. Typically, we require people to have caused some harm in order to be held liable for that harm. So, in other words, if I punch you in the face, I owe you the money for maybe the hospital bills or pain and suffering or that sort of a thing, because I caused the injury in your face. But if I tell my friend Dan, I really hate this woman, can you punch her in the face? And then he punches you in the face, it's not obvious necessarily, or I gripe to him, I really had a bad day and it was all this woman's fault, and then he punches you in the face. Am I on the hook for that? No, and I think the gun is closer to the second case than the first case, because they create a product and the product goes into someone's hands and something happens with that product, and it's not always, and it's not foreseeable in any particular given case. And so we can ask for a variety of different legislative solutions, but I would just say that there are serious constitutional problems with putting people on the hook for things that they don't cause.
I just would like to touch on the foreseeability issue. I think at the end of the day, foreseeability is usually a question for the judge and it's a question for the jury. That's how we treat foreseeability everywhere else. And PLACA, in a lot of cases, the federal government has taken that away from state judges and from state juries. And I want to touch on one mass shooting, because I think we are here in part to talk about mass shootings. And this is a mass shooting that happened back in the early 2000s, the Beltway sniper, I think very infamous around here. John Malvo and Muhammad acquired a Bushmaster and essentially were killing people all around Beltway. So the victims of those shootings sued Bushmaster, and this was before PLACA, and said, Bushmaster negligently provided the firearms to Bullseye Pawn Shop, I don't remember the name of the shop exactly, and said that Bushmaster knew or had good reason to know that guns kept mysteriously going missing from this particular shop. And guns from that shop ended up with these killers. And the court said, absolutely, if it is foreseeable that your guns are going to fall into the wrong hands and you are not taking proper precautions that guns won't fall into the wrong hands, then that is a matter for the jury to decide whether you put the society in danger. So I do think...
and you think that case wouldn't go forward today under Plaka? Because it seems to me like that theory says that it should go forward.
It wouldn't be allowed to... You cannot bring, as most courts have interpreted, you cannot bring a negligence claim under Plaka. I think we haven't really talked about exactly what Plaka does, and I think it's worth mentioning it here. Plaka says no lawsuit by a gun violence victim, by someone harmed by gun violence, can be brought against the gun industry if they were injured by a gun, period, right? This in state or federal court, unless it fits in with these narrow exceptions, right? And there are exceptions. 3 of them don't apply. They're really applicable to the Attorney General, and 3 of them are more applicable to regular civilians. And courts have interpreted that negligence, which, Andrew, as you know, is obviously the most basic claim that a lawyer would bring or that a victim would bring. Negligence is not one of those exceptions. So many courts have said that no, you can't bring an ordinary negligence claim. Some have said that you can bring it when you combine it with a knowing violation of law. That's a lot harder to do than just being able to bring a negligence claim, just like anyone else that's injured by any other product would be able to bring.
Well, it was my understanding. Perhaps I'm wrong, and that's completely fine because that a negligent sale. That if you sold it to someone that you knew, for example, said, I'm immediately going to take this out and kill someone, that would be a kind of lawsuit that could still proceed in state court. So, and you're saying that's not, and that's a question I'm just not sure about. And then there's a question of whether that could be preempted. At that point, I might even have issues with that law as not being something that we necessarily would be a good exercise of federal authority. Part of Plaka, I think, I was trying to suggest earlier, may actually be constitutionally mandated. And it really is that case where someone stabs someone with a knife and then we try to sue, the knife manufacturer. I think that it's not just a question for the jury, that the Supreme Court has in numerous cases, and state courts historically have held all the time in the tort context, that you can't be held liable, and that it's a serious due process issue, and that it's a constitutional issue, and it's a state constitutional issue, that you can't be held liable for something that you didn't cause. And so I guess, I think to the extent that Plaka legislatively ratifies something that is enshrined already in the Constitution, I think that's fine. It's a little bit redundant, but I think that's fine. And so I guess my question then to Alla is that case with the knife? How is what you're asking for different from the case of the knife? Because
Sure, absolutely. I think it's a good question, and I do think that when people really debate Plaka and when people go into the intricacies, you end up kind of closer than you think you are, because I think it's very important that my personal view, and I know the Bradys' view in general, is if a gun company did nothing wrong other than sell a gun, and that gun happens to be used by someone, then absolutely the gun company should not be held liable, right? If they did nothing wrong other than legally manufacture a product and sell it, right? I think a great example is a case out of the Supreme Court of California. Again, all of these cases are before Plaka because, obviously one of the intended consequences of Plaka, because it was something that was pushed by the NRA, is that it would essentially scare lawyers to stop bringing these lawsuits. So a lot of these lawsuits are no longer brought and they're no longer tested. A manufacturer was advertising semi-automatic pistols out in California, and one of the things that Navigar is the manufacturer, he advertises that this gun was resistant to fingerprints. I don't know who would want a gun that's resistant to fingerprints other than a criminal who's intending to commit a crime with that gun. A criminal, in fact, did go out and buy these guns and then went into 101 California Street, there was a law firm there, and shot and killed 8 people. So I think that's a perfect example of, yes, the product is going to someone else, but there was something that the manufacturer, in my opinion, did really, really wrong. It was purposely marketing a product for very questionable reasons.
All right, let's take some questions from our viewers. Brent Yates asks, should gun manufacturers be held to the same standards as other companies? And I'll go ahead and start with you, Ala.
I would think absolutely. I think at the very least, the point of a firearm, the intended point of a firearm, is that it be able to shoot a bullet that will injure or kill someone. When you are making a product that, especially when it falls into the wrong hands, I think you have even a greater duty, a heightened duty, to make sure that it doesn't fall into the wrong hands, that you don't purposely market it into the wrong hands, and that you make it as safe as you possibly can, while also making sure that it's functional and that it does the job that it's supposed to do.
And Andrew?
Oh, I mean, the question is, should gun manufacturers be held to the same standards as everybody else? Absolutely, and I think that's exactly what I've been saying this whole time, is that the suggestion by certain gun control organizations with respect to gun manufacturers is that gun manufacturers should be on the hook for things that they don't cause.
And Kendra Phelps asks, shouldn't the focus be on gun sellers who break the law rather than gun manufacturers? And Andrew, we'll start with you this time.
I think the focus should be on common sense law enforcement, to be honest. And identifying and preventing crime and allowing for a society where people are more able to quickly respond to these sorts of attacks. If we're talking about mass shootings, I think I understand why we target gun manufacturers, or they have deeper pockets. They make a lot more money than the mom and pop shops that sell guns on the street. I think that someone on the other side would say, oh, we have to go after everybody all the time because we got to drain the swamp. But quite frankly, I think the focus should be on law enforcement and general tolerant norms of a law-abiding society.
I think that's a great question. And I don't think they're mutually exclusive at all. I think we should be concentrating. We in this country undoubtedly have a very serious gun violence problem. And I think we should try to figure out how to solve that problem in whatever mechanism we can, whether it's through lobbying, or whether through lawsuits, or whether through just through education and awareness. I personally represent victims where most frequently we do sue gun dealers, and I think that's very important. I think gun dealers who are the ones interacting with the potential dangerous purchaser do have a very important duty. They're the last ones, right, that see that person before they go out. So absolutely, I think gun dealers should be held accountable. I don't think that's mutually exclusive of gun manufacturers. And it's, that comment that they have deep pockets, I think that's kind of a remark that every plaintiff's attorney has to live with, right? But the reason that you go after gun manufacturers is because if they are the ones that did the wrong, if they are the ones that marketed their product in a dangerous way, then they should be the ones to change that, right? And also, if they have a larger market, they reach more people, then changing how a gun manufacturer makes guns and how a gun manufacturer makes guns saves more people's lives.
Okay, and now it's time for Answer This, where each guest asks a question directly to the other. Who would like to go first?
I'll just re-ask my question, which is the question of the knife manufacturer, because I know you started to answer, which is maybe I'll put it this way: should a knife manufacturer be held responsible for deaths when someone takes the object and uses it, and it works as intended, but it is misused by a consumer?
Sure, absolutely. So I think that's a great question, and I think there's a lot of confusion about it, right? when a manufacturer knows that they are selling a product and they are flooding a particular market or providing that product, that gun, to a particular dealer who they know is trafficking or have good reason to know is trafficking, I think absolutely those manufacturers should be held accountable for choosing to look the other way of, hey, where are my guns going? I know they keep being recovered in crime. I have all the statistics to show they're being recovered in crime, but I'm not going to ask any questions.
And do you have a question for Andrew?
I do, and it's a question that I've always wondered. Generally, tort law and civil law is a state matter. States develop their own law. Judges enforce it. Jury decides who's liable and who's not liable. Right. And PLCAA takes that away. From they say to a state judge, you no longer have the right to decide whether this is. Your state may have thought that this was a negligence for hundreds of years, but now you no longer have that right. The Congress said that to states. So I wonder how people on the other side of the aisle view that with regard to state rights.
Yeah, no, I completely understand the question, and really it's a tough one to answer. The question is, generally people on the conservative side like states' rights, but then why would they ever support federal legislation in the preemptive context? And I think that's a good question. What's a conservative view of preemption? I don't exactly know what the answer is, but I can say this. In certain situations where you have a national market that is being interfered with by states that are doing blanket protectionist measures or things which may violate federal constitutional rights, as I think in this context, I think it is both in the enumerated powers of Congress in Article 1, Section 8, and it may even be, I mean, it's a very good thing for the federal Congress to get involved. The question is whether in this context they've done what they should be doing.
Okay, that's all we have time for. We'd like to thank Andrew Kloster of the Heritage Foundation and Alla Lefkowitz of the Bradys Center for joining us to discuss the issue. Thank you.
Thanks for having me.
And thank you for watching Scholars Mate. I'm Susanna Woodhead. We'll see you next time.